the second-degree murder count. Again, applying Justice Thomas's reasoning, I find that the lesser offense in this particular case and set of facts is the aggravated battery with the firearm. Just as an aside, all those shots were done within a range of any place from 14 to so many seconds, but less than 30 seconds at the most. So I consider that one act. So they would all merge, but I'm not going to enter judgment on that, as Illinois requires that with one act, one sentence, one crime. So therefore, there'll be no judgment entered in on the aggravated battery with the firearm counts, and they will merge. I'll enter judgment on the second-degree murder count. Now, again, anytime it gets easy for a human being to sentence another human being, that human being, whether it's a judge or if it determined in a death penalty case, the jury, they should get out of the business, all right? So this is not pleasant and this is not easy, but this is some kind of a profession that I chose, and I'm not complaining about it. But I certainly have to take in consideration all the feelings that are involved here today and throughout the whole trial. And I want to compliment the lawyers here. I don't have the exact figures, but initially the amount of information that they had was 500,000 emails, maybe more than 100,000 pages of discovery. Laquan's DCF files were in the neighborhood of about 8,700. You people that have been here, you wonderful people, during the trial, know the expert witnesses, the reports that have been filed, the motions that have been filed. So both sides have done such a tremendous amount of work, and they're very professional. I want to compliment them. Now, moving on, you've been here today, and you've seen the impact that this crime has had on Laquan Mcdonald and his family. You've seen the impact on the Van Dykes and their family and the children. That's the shame. The family are suffering a tremendous amount of pain during this, along with Laquan McDonald's family and loved ones. And I've sat here time and time again, and along with my brother judges that are here in this courtroom, and it's just so senseless that these acts occur, because you can see the pain on both sides of the family. And I think Mr. McMahon said it in closing arguments in the case in chief. This is a tragedy for both sides. So this is not easy, and I don't expect it to be easy. My findings are an appropriate sentence would be 81 months in the Illinois Department of Corrections, 2 years mandatory supervised release. Mr. Van Dyke, you have two rights I have to inform you of. One, the first right is you have a right to have me reconsider your sentence. That means within 30 days, you'd have to file a written document called a motion to reconsider. In that written document, it must contain all the reasons why you want me to reconsider your sentence. If you could not afford an attorney for that motion and you wanted to have one in preparation of it, the state would pay for that attorney. Do you understand that right? You have to answer yes or no, or you don't know. Okay. The next right is you have the right to appeal both the trial and the sentencing. And again, within 30 days, you'd have to file a different written document, and that document is called a notice of appeal. If you could not afford the appeal, the state would pay for your lawyer, would pay for your transcripts and all filing fees if you couldn't afford your appeal. Do you understand that right also?
Yes, sir.
All right, thank you. All right, there'll be a short recess. Well, that's the end of it. Court's in recess.